Ms. Dayarathna, who is a lecturer in your faculty of law of the Kottadawala Defence University. She had graduated from the University of Colombo with honours. Her interest includes, I was told, law of delict, family law and human rights law. I kindly invite you to make your presentation.
Thank you, sir. My presentation topic is medical negligence law for a better approach in Sri Lanka. This is the organization of the presentation: introduction, research problem, methodology, discussion, recommendations and conclusions. First of all, I'd like to briefly discuss the significance of my research. Today, actually, the world highly speaks about human rights. Patients' rights are an important and also an inalienable part of those human rights. So as patients, they always want the best of care, and in a case of error, doctors wanted to treat the errors as human judgmental errors. So with the emerging concepts of patient autonomy and patient safety, medical negligence has become a debatable issue today. There's a continuous rise in medical negligence claims in Western countries. So it directly affects clinical freedom. At the end, doctors tend to take defensive actions when treating their patients. So doctors are expected to use their special expertise, knowledge and skills to save patients' lives without being negligent. And if a patient suffers an injury due to the negligence of a doctor, there's a remedy available under the civil law, that is to file a medical negligence lawsuit in the court. Medical negligence lawsuits are civil actions which is designed to determine whether the doctor has breached the required standard of care and whether such negligence has caused the harm. In English law, if we draw the attention to the English law, number of tests have been developed to identify the required standard of care by the doctors. On the other hand, in countries like Sri Lanka, due to lack of knowledge and lack of awareness, people rarely challenge doctors and go to courts because of the inherent weaknesses which is associated in the civil litigation procedure and the fault-based civil liability system in Sri Lanka. Also, due to the inherent weaknesses in the fault-based liability system, civil liability system, and the adversarial litigation procedure in Sri Lanka, it is doubtful whether an ill person be able to claim compensation under the medical negligence law in Sri Lanka. So, the main research problem of my study revolves around some key issues in the medical negligence claim and also regarding lack of awareness about the remedies associated in a medical negligence situation, and also how Sri Lanka can best respond to patient safety approaches while reducing the number of claims which comes before courts, and also providing an effective solution to redress victimized patients in Sri Lanka. From time to time, through media, we can hear so many problems between doctors and patients. Actually, doctor-patient relationship is it's a fiduciary relationship which is based on trust. Both the doctors and the patients are not aware of their rights and the duties that they are obliged to perform over the society. Even though the legal framework exists to address these issues, even though the legal framework exists in the country, a problem arises with regard to the adequacy, suitability, and the awareness of the framework. So the issues remain unresolved, and finally parties just point the fingers to each other. Same thing happens over and over again, just deteriorating the doctor-patient relationship, and finally just making a hot news for the mass media to be published. So this research emphasizes the necessity of a paradigm shift in the way that the legal standard of care should be determined in a medical negligence claim, and also emphasizes the necessity of introducing alternative methods to deal with medical negligence claims in Sri Lanka. The methodology, when I discuss about the methodology, information and data in this research were gathered by analyzing various law journals, articles, cases and books in the area of medical negligence law, and several reforms to the Sri Lankan law have been proposed in the light of analyzed case studies and identified best practices. These are the findings of my study. Basically, medical negligence means breach of standard of care towards a patient by act of commission or omission ultimately results in damage to a person. For a successful medical negligence claim, patient have to prove 4 elements. Out of those 4 elements, a hard factor for the patient to be proved before the court is that the required standard of care by the doctors. So, traditionally, it was determined based on the Bolam test, which was introduced in Bolam versus Fine Hospital Management Committee case, that's an English case. And according to the Bolam test, doctor was not guilty of care if he has acted in accordance with the practice accepted by responsible body of peer professionals. Actually, the Bolam test is highly deferential and overprotective towards doctors because it's basically reliant on medical testimony. So, the House of Law judgment in Bolito case introduced a 2-stage test, a logical analysis and a risk analysis test, and declared that standard proclaimed by the doctors have to be justified on logical basis considering the risks and benefits of competing alternatives. So, in this slide you can see several cases which has applied both the Bolam and the Bolito test in order to determine the required standard of care by the doctors. Negligent liability of a doctor also can arise if the doctor fails to disclose all necessary information for the patient. So, in today's modern medical practice, doctors are obliged to disclose all material risks inherent with the treatment, and the patients are required to give the consent with full understanding. However, due to the knowledge gap and due to the hierarchical structures within the society, there is no adequate discussion between the doctors and the patients. In Sri Lanka especially, patients hesitate to talk with doctors and to take advices from the doctors. So, it is doubtful whether the form which is used to take the consent of patients can be taken as a real indicator of the informed consent, and also such forms does not reveal each and every risk in Sri Lanka. So, a problem arises with regard to the informed consent in a medical negligence claim in Sri Lanka. And also causation. Causation is also a debatable matter in a medical negligence claim. When there are several combined causing factors and when the defendant can prove that irrespective of his or her negligence that the damage can occur, that also can lead to fail the claim. When we draw the attention to the human rights perspective, human rights is a fundamental principle in any legal system. So, Universal Declaration of Human Rights, International Covenant on Civil and Political Rights, International Covenant on Economic and Social Cultural Rights, and also the South African Constitution have identified right to health, right to life, patient autonomy, and right to be informed as fundamental rights and human rights. So, when we turn our heads back to the Sri Lankan law, in Priyani Soisa versus KNT Dayarathna case, Sri Lankan judiciary reviewed the medical negligence law in Sri Lanka with far-reaching implications. And in that case, it was declared that despite the fact that the negligence has established failure to draw the distinction, failure to draw the causal nexus between the negligence and the damage has led to fail the claim. So, according to the Priyani Soisa judgment, and also due to the practical problems which is associated in the adversarial litigation procedure in Sri Lanka, it is doubtful whether an ill person be able to claim compensation under the medical negligence law in Sri Lanka. So, these are the recommendations of my study. Many countries have identified the necessity of moving away from fault-based liability system to no fault-based liability systems. New Zealand is a best example for that. In New Zealand, they have introduced no-fault compensation systems to address medical negligence incidents in 1972. And in 2005, they have introduced a new concept called treatment injury to cover all adverse medical incidents. And they are maintaining an account called treatment injury account to cover all adverse medical incidents, and which is maintained by government taxation. So no-fault compensation systems remove the requirement of proving the fault and the negligence and compensate based on the loss. So with regard to medical malpractice, compensation is paid for a proven injury which has occurred unnecessarily through treatment. So and also France, Sweden, Denmark have also moved away from the fault-based compensation systems to no-fault-based compensation systems in order to deal with medical negligence situations in those countries. And also countries such as UK, USA, and Australia, Belgium have embraced alternative dispute resolution mechanisms to settle medical negligence claims in those countries. Actually, they have identified that ADR as a best method to address both parties' concerns, and compared to other alternative dispute resolution mechanisms, these countries have identified, and also these countries are using mediation as the best method to address the unique characteristics of the doctor-patient relationship in a medical negligence claim. Sri Lankan adversarial litigation procedure is both costly and time consuming, and also due to the practical problems such as lengthy period in pursuing claims, and the procedure is adversarial in nature, and especially in a medical negligence claim, the patient have to prove that the doctor has breached the standard of care, and doctor's breach of standard of care has a significant and material connection with the ultimate damage. So it is a very hard factor for a patient to be proved before the court. So as I explained earlier, causation and the breach of standard of care is basically based on medical testimony and medical judgment. So it is a very hard factor for a patient to be proved before the court. So a problem arises with unreliability of witnesses, and also when the doctors are in a highly litigious environment, doctors tend to take defensive actions, not to further the diagnosis of the patients, but to avoid litigation. So, and another point I want to highlight here, one of an unfortunate consequence of court litigation is that it makes parties against each other, alienates each other. Doctor-patient relationship is a fiduciary relationship which is based on trust. So patients have a great deal of admiration and respect towards doctors. So those feelings can be destroyed and lost with the court litigation procedures. So a system which focuses to address these issues, medical negligence issues, have to focus on promoting understanding, healing, and rebuilding connection between the doctor-patient relationship. And the other thing is both the medicine and the mediation has similar characteristics such as healing. So I think mediation is the best method to address disputes between doctors and patients in Sri Lanka. And also some countries such as USA, most of the states in USA are using pre-trial screening panels to screen out the non-meritorious claims. And also several constitutions, for an example, South African Constitution have recognized right to life as a fundamental right to health as a fundamental right, and also right to be informed as a fundamental right. So Sri Lanka 1978 Constitution have to include those rights, have to recognize those rights as fundamental rights in Sri Lanka. And when we are going to address a dispute between a doctor and a patient, actually we have to make a balance between the parties. So if we award large financial damages for the patients, it will always demotivate doctors. So doctors will tend to take defensive actions when treating patients. So countries For an example, USA is using damage caps to reduce the damages which are being paid for the patients. And also steps should be taken to educate the general public in Sri Lanka, and the other thing is proper documentation is essential, and it is needed to establish a good relationship between doctor and the patient. Our adversarial litigation procedure always discourage open and honest communication. Normal tendency of the doctors in Sri Lanka is to remain silent and not to reveal too much information for patients. So doctors are reluctant to discuss their errors because those evidences can be lead against them in court. So doctors should be given the assurance that the evidences, that their speeches are will not be used in courts as against them as evidences. And also it is the responsibility of the country to provide a platform for such a discussion. In that sense, I think mediation can be identified as a good solution to address medical negligence claims in Sri Lanka. So finally, I'd like to say that it is the responsibility of a country to strike a balance between the parties, that means the doctors and the patients, and it is the responsibility of the legislature, judiciary, and also the media to respond to the problems associated with medical malpractice claims by taking necessary steps to incorporate the best practices around the world into the Sri Lankan legal framework as discussed in this study. Thank you.
Thank you, Ms. Dayarathna, for adhering to the time and for making a nice thought-provoking presentation, and the questions and the suggestions will come after this session. We'll invite the next